Hi everyone, I'm Anja from Anja Opperman Attorneys. We're a law firm based in the north of Johannesburg, and while we do different kinds of litigation, my personal area of expertise is family law. Today I want to talk to you about urgent court. We touched on the topic when we spoke about immigrations. Obviously, the problem is that our court system is notoriously slow. It can take forever to get a matter through court, and while it's never nice or desirable to have to wait for a long process, sometimes it's actually highly problematic in the sense that if you had to wait for that long, the entire reason for bringing the application in the first place would have fallen away. So that brings us to this scenario. You've received a wonderful, lucrative opportunity overseas, and you really want to take it up, but there's a lot that needs to happen. You need to get your visas arranged, you need to sell your home, pack up, ship out, make a plan with the pets, find a place to stay on the other side. You have to look for schools there, and there's just so much to do. If on top of all of that, you also have a legal dispute about whether your minor child would be allowed to immigrate with you or not, that really can be a spanner in the works. And because there are set timelines for all of those other things that need to happen, this one issue could hold up everything and could eventually lead to the opportunity passing and you not being able to even pursue it. So in those circumstances, the wonderful, magical answer is to be able to run to the urgent court, which is the High Court. Under certain circumstances, it really is that magical that you're able to be in front of a judge within a matter of days, sometimes even hours, after knowing that you need to be there. But obviously, it's not as easy as it sounds. We can't allow any litigant to just run to court whenever they feel like it. That would cause complete havoc with the court rolls. So it really is very, very serious to have to convince the judge, before we even get to the merits of your matter, we have to convince the judge that you being there under such short notice is absolutely justifiable and that you need to be helped. Obviously, any client who runs to urgent court, they feel that their matter is urgent and they do have grounds. They can all say to the court, I need an order now. But that actually is not enough to convince the court, because there are all sorts of technical factors that we have to look at around urgency to be able to cross that hurdle. And only if the court is satisfied that we have addressed all of those issues, we will be able to proceed to the merits of the matter. One of the things that we really need to hammer on is to make sure that we haven't created our own urgency. If the court at all catches whiff of the fact that you didn't act as soon as you possibly could have acted, then it won't help you, because it will say that this urgent situation could have been avoided had you taken certain steps. The most important thing to remember is to do whatever humanly possibly can be done from your side as soon as you know. You have to communicate with the other party in a very transparent manner and as soon as you know about anything. Even if it's not confirmed yet, but you think that there might be an opportunity on the horizon, rather take that step of caution, put it on a letter, because that really builds your case and you can show to the court that you did act in the way that you could have and you did try to avoid being in front of the court. In those circumstances, the court will really have sympathy and it will go the extra mile to try and assist you. The second thing to remember regarding urgency is that you are seriously curtailing the other party's right to respond to the matter. The other party has a right to come and set their case at court and to explain to court why they don't want this application to be granted in the way that you're asking for it. Normally, a party would have 20 court days, that's a month, right? Depending on what kind of an application it is, but that's a general timeline that a party would have to attest to their affidavit, and to go, for that they would go and see their lawyer and they would come up with a version that they're happy with to present to court to defend the matter. If you're going to cut that down to a number of days or a few hours, then you really have to justify to court why this is reasonable and why this is absolutely necessary. Otherwise, the court will not indulge it. So what we sometimes do in that regard is, if you do have a couple of weeks to play with, we use that to make sure that we are giving the other party as much time as we possibly could have given them to give their response. So that's why there's a difference between a matter of extreme urgency and a matter that still is urgent, but you have a couple of weeks to play with. We would motivate why we approach the court on what short notice. And if we can allow a couple of extra days, we would allow that couple of extra days, because that just goes to show that we've tried to be reasonable under the circumstances. Either way, we're not sticking to the normal rules of court, so it's still an urgent matter. The other thing that people forget is that even with urgent court, there still are rules, right? So in Joburg, for example, if we're going to the High Court, the directive says that we have to file all our papers, we have to have our matter issued, and all the papers filed by the Thursday so that we could be in court by the next Tuesday. If we're dealing with a matter of extreme urgency, then that sometimes is difficult and we can't stick to that. And again, there we do have the opportunity to deviate, but we really need to motivate the deviation and seek the court's special condonation for the fact that we haven't stuck to that rule. So basically in urgent court, the rule is that you can do anything, but it's not as easy as one might think. You need to show that you've done everything from your side, that you've gone the extra mile, you've been transparent, you haven't caused any delay in the matter, and that it's justified for this matter to be heard on such extreme, urgent, short time frame. If you can do that, your matter will be heard as urgent, and then obviously we get to address the merits of the matter, which is whether the child should immigrate in the first place or whatever the matter is about. So remember that urgent court's not only for family matters. This could pertain to a number of civil matters. It just depends on the circumstances and whether you have that grounds of urgency and can convince the court that you need assistance.